Good morning, everybody, and welcome to the First District Court of Appeals. We have several cases on the docket this morning. 2 are to be argued and 3 are submitted. The first case that will be argued is Twism Enterprises versus the Ohio Board of Registration. The board is represented by Mr. Honan. Twism is represented by Mr. Stauff. There are cross appeals in this case. And counsel, I understand that ahead of time you have discussed how to handle that. And my understanding is that Mr. Honan will argue and reserve some time for rebuttal. Mr. Stauff then will argue and reserve some time if he wishes for rebuttal on the cross appeal. And each side will have a total of 15 minutes. Is that your understanding, Mr. Honan?
So that's my understanding, Your Honor.
All right, Mr. Stauff, is that your understanding?
Yes, ma'am, it is.
All right, Mr. Honan, you will go first. How many minutes would you like to reserve?
If I could, 4 minutes to reserve for rebuttal.
All right, and I will keep your time. Whenever you're ready, you may begin.
Good morning, Your Honors. May it please the court, Brian Honan, Assistant Attorney General here on behalf of the Board of Registration for Professional Engineers and Surveyors. Twism Enterprises is an engineering firm that doesn't have an engineer on staff. They have one member. The sole member is Sean Alexander. He is not an engineer. Instead, they subcontract out for engineering services to be provided by James L. Cooper Professional Engineering. Mr. Cooper has his own certificate of authorization and performs engineering services under that certificate of authorization. Twism refers to Mr. Cooper as a 1099 employee, but the board submits that there's no such thing as a 1099 employee. If you're paid through a 1099, you're an independent contractor, you're not employed. So therefore, there's no employee under Twism. There's no full-time partner, member, manager, officer, or director of Twism that performs engineering services. And therefore, the board denied Twism's application for a certificate of authorization to perform engineering services in Ohio. This particular arrangement risks allowing Twism to dodge accountability to the public for engineering services provided under Twism's name. This isn't merely speculation. Twism's already attempted to dodge accountability to the board when the board was investigating unlicensed activity on Twism's part prior to Twism's application. So this is something that has happened. So it is a reasonable fear of the board, a reasonable concern of the board.
So you're saying that Twism would not be responsible for the actions of a 1099 independent contractor?
I'm not determining whether or not they'd ultimately be responsible, but they would. It's at least an argument that could be made by Twism. It's something that they could use to attempt to deny or to dodge responsibility that could result in litigation. And the board's duty is to avoid that kind of confusion to the public. At a very minimum, it could cause confusion as to who someone is. I'm sorry, Judge Myers, you seem like you want to say something. I keep cutting you off.
I think I was cutting you off too. I just had a question because I want to make sure I understand. Your position is it would be the same thing as if I tried to open up an engineering firm and I didn't have an engineering degree, but I subcontract with somebody who does have an engineering license and hold myself out as an engineering company. Is that sort of that's what we have here on its very basic level?
Correct. And as you stated, it would be exactly as you, Judge Myers, attempted to, you could just start under this type of arrangement, could start, in fact, your own engineering firm, like you said, and just subcontract out to an engineer and call yourself an engineering firm, being the sole member, owner, partner, manager of that firm. And in this case, that could cause great confusion. And obviously, I'm not 100% sure of your qualifications, but I don't believe you're a professional engineer. And so you couldn't provide engineering services without subcontracting out. So as a matter of policy,
the law doesn't explicitly say that you can't do that. And I guess I question because, you know, the court below said that you all were reading something into the law that's not there. And I understand member, partner, those kind of word choices indicate that they are an employee or part of the firm. But what about the word manager?
So manager, so under this agreement, under Twism's agreement, they've written up a contract that states that Mr. Cooper is the manager. They've given him the title of manager. But to that effect, it's more the definition of full-time that describes you have to be the full-time partner, manager, member, officer, or director. So in this case, we'll just talk about manager, since that's what's being alleged here. You have to be full-time. Full-time is described in the administrative code as working either 30 hours or substantially all of the engineering hours for a firm. In this case, Mr. Cooper doesn't work the hours for the firm. Mr. Cooper works the hours for his own company, James L. Cooper Professional Engineering, that has its own certificate of authorization. He's then subcontracted out for those engineering services on behalf of TWISM. But he doesn't work for TWISM, and the administrative code requires him to work for TWISM. Specifically, it's 4733-3902. And so the board has interpreted that as meaning you have to be employed by, you have to actually work for the board, or I'm sorry, for the firm.
Interpret it to mean that he does work for TWISM, like he's doing work for them, rather than.
I suppose that's an interpretation that could be made. However, as the lower court, the biggest mistake the lower court made was substituting its interpretation for the interpretation of the board. The lower court was supposed to defer to the board's interpretation of its own rules and statutes.
Mr. Honan,
Yes.
Let me ask you this. Do we have to defer to the board if we find that the statute and the rule are unambiguous?
If they're unambiguous, no. If the language is clear, and in this case, the board would argue that the language is clear, but it requires that he works for the firm, and to work for the firm, you have to be employed by them or have an ownership interest in them. You can't just be subcontracted out by them. It would be the same as saying if you, in a construction contract, which actually are described in the Ohio Revised Code, if you hire a general contractor and he subcontracts out to a plumber to do the plumbing work on your house, that general contractor doesn't get to call himself a plumber. He's not a licensed plumber. He doesn't get to say he's a plumber. He gets to subcontract out to a plumber. And that specific circumstance is actually covered in the Revised Code. It's 4733.161, and it's titled Unauthorized Practice. And there's actually the requirements for a subcontracting arrangement. And in fact, in Chapter 4733, it's the only part that describes a subcontracting relationship. And it specifically states that in a construction contract, you can subcontract out engineering services, but the construction contract has to be performed, or the construction work has to be performed by the construction company that is contracting with the client. The engineering services, so the company that is offering the engineering services has to be the one doing the building. The company or individual that's providing the engineering services has to be licensed. And then that same statute goes on to say any other arrangement cannot be done. If you do not use this particular arrangement, if you're not actually building or perform the construction on the real property, or you're not and you're not having a licensed engineer perform this on your behalf, you cannot subcontract out engineering services. It specifically excludes any other relationship, which would be this particular relationship here. Mr. Alexander, through TWISM, doesn't provide construction contracts, or at least it's not alleged in his application that that's what he intends to do. He is intending to offer to provide services as an engineer without having any engineer on staff, and instead subcontracting out an engineer. That is at best confusing to the public, and at worst could cause, there's at least a possibility that they could dodge liability, as they've attempted to do through the board. And so because to really go in a roundabout way, Judge Bach, to answer your question, the statute in the board's determination is unambiguous. It says you have to work. However, if the statute is determined to be ambiguous, if full-time can be determined as, if working for could be determined as either subcontracted out or actually working for, then the board's interpretation of that ambiguity should be deferred to unless it's unreasonable. In this case, it's reasonable. Not only does the language of the rule and the statute point towards that, and plus the language of the immediately following statute, 4733.161, point to that interpretation, it's also reasonable to protect the public, which is the job of any administrative board, is to protect the public from unauthorized practice, or from any harm due to the practice that they're tasked to oversee. So in this case, it's a reasonable decision. The lower court should have deferred to the board's interpretation and instead substituted its own interpretation for that of the board.
Let me ask you this, Mr. Honan. This is kind of a side issue, but it just occurred to me. The statute says full-time manager. If there were somebody who were operating as a full-time manager for TWISM that was a subcontractor, don't the labor laws require that they be hired as an employee? I'm not sure it's permissible to have a full-time sub 1099 person without violating the employment laws. Am I remembering that correctly? Or do you, and it may be not an issue in this case.
I can tell you that I wish I could answer that question better, but I'm not, I don't deal in employment law very often, so I don't know the answer to that question. It seems logical that that would be the case, but I can't for certain state that that is the case. It should be, and in this case, that's how the board interpreted it. However, I'm not certain that that is what the labor laws state.
You have about 1 minute left.
Okay, then I really quickly want to also touch on the attorney's fees, because the lower court properly denied TWISM's motions for attorney's fees. And the standard for that was, of course, that the rationale of the board has to be supported by an articulable, or I guess the initial denial had to be supported by an articulable rationale that a reasonable person could find substantially justified. In this case, the best argument for that would have started with Judge Luber's in the argument specifically for this, for the attorney's fees motion, where she gave an analogy of a professor that said, if something seems wrong, just object to it, even if you don't know why. And in this case, in her mind, this seemed wrong, and she would have objected to it just on its face. But besides that, it was also the board had a reasonable interpretation of the definition. There is certainly a way to interpret working for as actually working for. And the board had a reasonable articulable rationale for that, and also protection of the public.
And you are at your time, Mr. Honan.
Okay.
Mr. Stolf, how much time of your 15 would you like to reserve?
Your Honor, 5 minutes, please.
All right. Whenever you're ready, and I will
All
keep
right.
your time. Can I start by asking you a question? I just want to
Of course
narrow,
you can, Your Honor.
this issue. I assume you would agree that he is not a full-time partner.
Well,
Correct.
Your Honor, it depends upon what the word full-time means. And the
No,
board,
partner. I'm focusing on partner. He's not
no,
a
I'm
partner,
sorry.
correct?
yes, ma'am, he is not,
Okay. He's not a member.
correct,
He's not an officer.
correct,
He's not a director.
correct.
And all of those terms are defined somewhere in the Ohio Revised Code under the statutes that deal with corporate organization. A member, I would argue, also is a member of an LLC. A partner is a partner in a partnership or an LLP. Officer, director, defined terms. So focus on manager. Why isn't that the same thing? He has to be a full-time manager of the entity. And how can you be a manager for an entity if you're not employed by the entity?
Well, because, Your Honor, the statute, or I'm sorry, the rule that the board promulgated defines full-time as meaning working 30 hours per week, which is not full-time under the labor laws, working 30 hours per week, or
For that would you agree for that entity? I mean, it has to be a full-time manager of the entity.
No, yes, ma'am. But the board has defined full-time as being working 30 hours per week for that company, or, and this is the key, substantially all of the engineering hours of the firm. And the judge concluded below that he did meet the full-time requirement under the rule because he worked not substantially all, he worked all of the engineering hours of the firm.
I guess I'm focusing on the word manager. How can you be a manager of an entity if you're not employed by the entity?
Because
And go back to my example. What, under your theory, why couldn't I start an engineering firm, hire a licensed engineer to do all of the work that I'm able to bring in and call myself an engineering firm?
Okay, well, Your Honor, that's one of the points I wanted to bring up is TWISM does not hold itself out as an engineering firm. TWISM is not an engineering firm. What TWISM does.
Holding myself out as providing engineering services then.
Well, what TWISM does is TWISM, number one, this is a company that's in transition. It's trying to be formed and get off the ground. He doesn't have 30 hours per week of engineering hours to give Mr. Cooper. He's got substantially less than that. At the time of this application, he only had 5 jobs. So he's trying to get this off the ground. But the thing I want to correct is TWISM does not hold itself out to be an engineering firm. What TWISM does is TWISM basically contracts with electrical contractors to basically draw plans, CAD drawings. And one of the things that you've got to do if you're doing an electrical job is those plans have to be approved by the building department. And in order to get them approved by the building department, they have to be reviewed by a licensed professional engineer. And so drawing the CAD drawings is not an engineering function, but there is engineering that goes into it. And that's Mr. Cooper's role. And the testimony was unrebutted is he performed all of the engineering hours. He provided testimony in the hearing that what he did is when Mr. Alexander got a job, Mr. Cooper would go to the job, look over the job, talk with people, take measurements, whatever, and then provide guidance to Mr. Alexander to draw the CAD drawings. He would then review those CAD drawings, make changes based upon his engineering knowledge. Sean Alexander would then make those changes, and then Mr. Cooper would review it again, sign off on them, and those would get submitted to the building department to get approved. So TWISM is not an engineering firm, it's a CAD firm.
Mr. Stolf, I'm going to go back to what Judge Myers was asking about, because I was curious about this too. So the statute has a list, and that list is partner, manager, member, officer, director. Manager's in the middle there. So since all of the others clearly have to be associated as with the firm itself, how can a manager not be an employee or more closely associated with the firm?
I don't know how more closely associated you can be, Your Honor, than being what Mr. Cooper was. What is an employment? What is employment? It's a contract. It's an employment contract. The main difference between an employee and an independent both of them have contracts with the firm. Both of them have an established relationship with the firm. And what we argued to Judge Lubers below and the hearing officer, and Judge Lubers agreed with that, is that an independent contractor is very closely tied to a firm.
But you couldn't get insurance. Your client couldn't insure insurance that would cover the work of an independent contractor, could it?
Your Honor, I don't know. Nobody's raised that issue. But again,
those are all the things for employment that the statute, the purpose of the statute, there's no workers' comp being paid on them. There's no withholding presumably being done. There's no employment rights. It's not an employment relationship. It's an independent contractor who, according to the law, has the ability to determine how to do the work, not your client. Your client can't direct the work of an independent contractor.
And I agree 1,000%, and that's exactly what we argued below. And the court agreed, because you don't want Mr. Alexander overruling Mr. Cooper on engineering matters. You want Mr. Cooper, the board should want Mr. Cooper to have that independent relationship. And he testified before the hearing officer. That's exactly what he did. He was offended that anybody would even suggest that he would be kowtowing to whatever Mr. Alexander wanted. So I think an independent contractor relationship only furthers the public interest and safety. It doesn't do anything to minimize it. And
then how is he a manager? How is he a manager if he can't manage the employees of the company or manage the business of the company?
But he's the engineering manager, and the testimony undisputed is that he does all of the engineering work for the firm. There aren't any other employees that he's supervising. He's doing the work himself as a licensed professional engineer, but he is the engineering manager of the company. He's designated, the law required TWISM to designate someone as its engineering manager, and TWISM did that. And so he meets the requirements of the statute as a manager. He meets the requirements of the regulation as working full-time because he works all of the hours.
Can you address
Isn't
Mr. Honen's
manager-
argument? I'm sorry. Can you address Mr. Honen's argument that somehow TWISM would get out of liability for things that are done by this 1099 worker?
Yeah, I don't understand how that could possibly be. Again, TWISM is submitting this. TWISM is doing the CAD drawings. If the engineer is wrong, as a licensed professional engineer, he's going to have his own responsibility. But the board, TWISM is holding Mr. Cooper out to the world as its engineering manager. That's why they've got the COA, which designates Mr. Cooper as TWISM's engineering manager. I, for the life of me, don't know how they get out of responsibility for that. He's clearly an authorized agent of the company, and whether he's an employee or not doesn't make any difference. He's under contract to perform engineering services, and if those services are wrong, then TWISM is going to be held liable, just like Mr. Cooper probably will be too.
But there was some reference made that TWISM's already tried to get out of liability somehow.
Yeah, and I wanted to bring that up. Thank you, Your Honor. That is incorrect. Mr. Honen said that they were first brought up because they were doing illegal activities. What the illegal activities that they were brought up on is they were operating without a certificate of authorization. That was it. They weren't doing anything else. They didn't have a COA. That's what prompted the board's investigation originally, is somebody apparently reported him saying, hey, these guys are doing work on a job and they don't have a COA. That's what prompted Mr. Alexander to apply for the COA. And then we're here where we are today. So that's the illegal activity, is they were operating without a COA. That's completely irrelevant to what we're talking about here. There was no allegation they were doing anything else improper.
Mr. Stoff, you are at your time if you want to reserve 5.
Thank you.
All right. Mr. Honen, you have 4 minutes remaining.
Okay, first I'd like to start regarding the attorney's fees issue, and just to quickly once again state the standard is abuse of discretion. The lower court was well within its discretion to decide that the board's denial was reasonable, even if the Judge Lubers ruled eventually that the board that she disagreed with the board's interpretation. Their interpretation was certainly reasonable, and she was well within her discretion to deny the attorney's fees motion. And that should be, the court should uphold that portion of the lower court's decision. I want to address a couple of Mr. Stoff's arguments. First and foremost, he states that the law requires TWISM to designate a manager. That's incomplete. The law requires TWISM to designate a full-time manager, and full-time is defined as working substantially all, in this case, substantially all, because it's not 30 hours, and we all agree that TWISM doesn't have 30 hours of engineering work, but to work substantially all of the engineering hours for TWISM. Mr. Cooper doesn't do that. Mr. Cooper works substantially all of the engineering hours, in fact, works any engineering hours for James L. Cooper Professional Engineering under his own certificate of authorization.
Doesn't that definition, though, seem to imply that the person could also be working elsewhere, though?
I'm sorry, what was that?
Doesn't the definition of full-time then seem to imply that the person can also be doing engineering work elsewhere at other firms?
It doesn't necessarily imply that, and in fact, it's rare that the board would ever allow that. It does, all it does state is that if a board or if a company doesn't have 30 hours of engineering work, you can still consider it full-time as long as you're doing all the company's engineering work. It doesn't in and of itself allow for working for another firm. And in fact, it is rare that the board will allow someone to have a certificate of authorization for 2 separate companies. They want the responsible in charge to be responsible in charge for that firm, and for that to be achieved, that engineer has to be available during all of the engineering hours for that firm. Has to work all the engineering hours for that firm. So yes,
Mr. Honen. So what I'm not understanding here. So if TWISM were to get the certificate, would Mr. Cooper then be doing the engineering hours for TWISM?
That's what the certificate would mean. So a certificate of authorization, and one other thing to just correct, the reason TWISM was being investigated is because they were offering to provide engineering services in Ohio, which requires a certificate of authorization. So, and when TWISM was asked about that in the investigation, they specifically said, we don't do that. It's James L. Cooper Professional Engineering that provides those services, not TWISM, which is what the board agrees with. That is true in this case. TWISM's not providing engineering services. James L. Cooper is. So in this case, so if TWISM were to gain a certificate of authorization, they would then have the ability to provide or to offer to provide engineering services, but wouldn't have the ability to actually provide engineering services. They still have to subcontract it out to James L. Cooper Professional Engineering or any other professional engineer. They could subcontract it out. Again, Mr. Cooper provides those services. He works full-time for James L. Cooper Professional Engineering, and then he's subcontracted out to do engineering services when TWISM needs them. And just to counter Mr. Stoff's, to address Mr. Stoff's description of how TWISM is a CAD company that does electrical drawings for construction contracts. That's only allowed to be done under the statute. It specifically makes clear that if you're going to subcontract out engineering services for a construction contract, you have to be the one providing the actual construction work on the real property. And TWISM's not doing that, or at least they haven't alleged that they're doing that, and they haven't applied to operate in that. They are asking to operate.
You are at your time.
Then
You
I
may
thank
finish
you.
that sentence if you'd like, and then you're at your time.
TWISM is operating as basically a clearinghouse or as a broker for engineering services, and that's not permitted under the statute. And I ask this court to reverse the lower court's decision based on it. Thank you.
Thank you. Mr. Stoff, you have 5 minutes, and I want to turn your attention back to something I sort of started with. And that is, all of these terms are defined under the corporate code, including there's discussion in 1705.282 of a manager of a limited liability company. And it talks about somebody who's been appointed in writing and agreed to serve as manager, and et cetera, et cetera. Why shouldn't we give the terms in this statute their defined meaning under the corporate code? And I know that there's a new statute coming into effect in 2022 that defines manager, I think, further defines it. But why don't those definitions under corporate law apply here? They sure seem like that string are defined terms.
Your Honor, that I have not looked at 1705.282, so I apologize for that. If the court finds that that applies, I mean, all I can say is that from what you read, I think Mr. Cooper meets that definition. He's appointed. TWISM is holding him out to the world as its engineering manager, as the person in responsible charge, a defined term, responsible charge of the engineering activities of the firm. And he meets all the requirements of the statute. If I could turn my attention to the attorney's fee argument, this is a question of statutory construction. At oral argument, the board said that it had never allowed an engineering manager to be an independent contractor of the firm. We objected to that, similar to the argument that Mr. Honan just made. They keep bringing things up that aren't in the record and they never relied upon before. The big thing is Judge Luber said the employee is not an employee is not mandated by the plain text of the statute, and the court will not add a requirement that's not in the revised code. The Judge Luber said that the board created new substantive requirements not found in the revised code, which could not have been interpreted or understood by any applicant, and therefore the board's interpretation of the statute and the rule was unreasonable. That's all in her entry. And in denying the award for attorney's fees, we said, Judge, we think you've already found it. And her explanation on the record in the transcript was that I think the board felt that they were justified in giving the decision that they did. And the board was, quote, trying to protect the public interest. And I don't think they abused that. That was Judge Luber's rationale for denying attorney's fees. And I just go back to the question for this court is, was that an abuse of discretion for Judge Luber's to deny the attorney's fees? This man has been put through the ringer for reasons I don't understand. When the plain text of the statute, the plain text of the rule says nothing about somebody needing to be an employee. And all the rationale, the only rationale that the board argued for is belied by the evidence. There's no reason why a company like TWISM cannot exert control over the independent contractor. It's a matter of the contract relationship. And again, if you want to promote the public interest, you want that engineering manager to be an independent voice. You want him to be able to say to his, contracting partner, no, that's not going to work. That doesn't meet engineering standards. If he's an employee, the board would be faced with the opposite situation where the company is going to say, you know what, employee, you're not going to do this. The employer's got control over the contractor, over the engineer, and that's contrary to the public interest. So I think Judge Luber's was right in her original decision. I don't know why she changed, other than her thinking that, well, the board thought they were substantially justified in doing this. Nobody's impugning the integrity of the board. Okay, I'm not suggesting they were doing something for a malevolent person. That's easy for me to say, I guess. But the point is they're just wrong. And they created new substantive requirements.
If we decide that this is ambiguous, don't we have to defer to their interpretation?
Well, I don't think so, because again, they're not employment experts. And again, you look to their interpretation and the reasons they gave. You want somebody to be able to exert control over the engineer. You want them to be able to bind the company. All those things are found in the independent contractor relationship. So all of the articulated rationale for why the board did what it did, why it decided what it did, don't make any sense. In fact, I would argue, and I have argued, the contrary makes sense. This situation, if the court looks at the testimony of Mr. Cooper, I submit that is exactly the relationship that the board wants. Mr. Cooper flatly rejected, I don't know if the court is familiar with the term plan stamping, but that's a big concern in the engineering industry, is that engineers are just going to come along and just stamp something and then get paid $100 for doing it. And that was the original argument that the board made, is, hey, we're concerned about plan stamping. And this is all in the record. And that's why I called Mr. Cooper to testify, to say, number one, he said, I resent the board's even insinuation that I'm doing that. I've been a professional engineer for however many years he's been. I think it's been over 35 years. I would never do that. I'm not doing it in this case. And in this case, everything about the arrangement that TWISM had with Mr. Cooper is exactly what the board should want. I don't know why they don't want it. They keep saying the board has never approved an independent contractor to be a manager of a firm. That's completely not in the record anywhere. That's an argument council's made. We never heard that before until.
Mr. Stolf, you are at your time. I'm going to let you finish that thought. And then I have one clarification for you that I'm also going to let you comment on.
All right. I think I'm finished, Your Honor. I just think the board, or the Judge Luber's, was absolutely correct in her initial decision and absolutely wrong in her other decision denying attorney's fees. And I would ask the court to reverse her on that and remand it back for a determination of what attorney fee award would be appropriate. Thank you.
I just wanted to make clear, in that question where I was citing you that statute, I wasn't suggesting that statute applied. I was only suggesting that manager, as used in the corporate code, is a term of art. And that was an example of where it was being used. So I didn't want there to be any confusion. I wasn't suggesting that statute applied. And if you'd like to comment on that further about whether manager is or isn't a term of art, I'm going to let you do that because I think I was unclear in my question.
Well, I think manager, I don't know what manager means in the board's regulations. It's, I guess, in that sense, it's ambiguous what manager means, but there's no question that the statute is unambiguous as far as what a manager does. He's got to have direct or indirect supervision over the engineering activities of the firm. That's how manager is defined. That's how full-time is defined in the regulation, and that's what Jim Cooper met.
All right, thank you. Thank you both for your arguments today. We will take this case under submission and give you a timely written opinion. And again, thank you both and have a wonderful rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Hayden, if you will admit the next case into our courtroom. Good morning, Mr. Garswood. We can see your name, but I don't know if you intend to turn your camera on.
I do. When I click start video, it says you cannot start your video because the host has stopped it.
Ms. Hayden, I will ask if there's something on our end that's preventing his camera.
There we go.
All right. Mr. Garswood is here on the case of University Hospital versus Wells. This is a case where the appellant has filed a brief. We have had no brief from the appellee. Mr. Garswood, you will have 15 minutes to argue this morning. I will keep your time, and whenever you're ready, you may begin.
Thank you, Your Honor. Good morning, and may it please the court. My name is John Garswood, and I'm counsel for the appellant, the University Hospital. This case presents a sole issue to the court whether submission of a medical bill constitutes prima facie evidence of the reasonableness of the charged amount in an action on account or a collections matter. Accordingly, the University Hospital asked this court to align its holding with the only other two districts in the state of Ohio to decide this issue and rule that submission of the bill is prima facie evidence of reasonableness and either enter judgment in the full amount or remand this matter for judgment in accordance with that ruling. There are two cases presented to this court for review, both in the brief. The first is the 6th District's decision in St. Vincent Medical Center versus Seder. There, the court extended revised code 2317.421 to a collections matter. The court held that a hospital was entitled to the rebuttable presumption of reasonableness. However, the patient prevailed when it presented evidence to the contrary or relied on the evidence of the insurance company in that case. And the hospital failed to properly respond or rebut that evidence when the burden shifted back onto it to establish the reasonableness of its own charges.
Do you think that personal injury statute applies?
I do, based on the extensions of the personal injury statute in both Seder and in Middleton.
So you think those courts got it right?
Correct, yes. They actually rely on some language from Wood v. Elzohary as well, which again is in the context of a personal injury matter. But everybody seems to rely on the principle that the submission of the medical bill is prima facie evidence. And again, it doesn't necessarily it doesn't at all preclude the patient or the defendant or whoever it may be in that matter, because it could be an insurance company as well, from presenting evidence to rebut that presumption.
Can I ask a quick question though on that? So the statute on its face says it in an action for damages arising from personal injury or wrongful death. So it doesn't specify collection matters. Now you're saying courts have extended this to collection matters. But I guess my question for you is, what is the point of this statute? Why create a presumption, a rebuttable presumption in personal injury and wrongful death cases?
Well, it allows a medical provider, or I guess in a personal injury case, it would also allow injured party or plaintiff or whoever it may be to put on the evidence of the medical bill. And again, it was addressed in Jacques v. Manton and in Robinson. In rebutting that evidence, they allow evidence of insurance write-offs. So that's obviously not an issue in this case. The patient was uninsured, but it basically simplifies the process in submitting a medical bill, not having to call in a billing expert every time that you need to submit a medical bill, which would drastically increase the cost of litigation for both personal injury attorneys and attorneys like myself.
So why would we extend this then to collection matters? I mean, I'm just trying to understand when the statute seems to be very clear on its face, and clearly the trial judge below did not think it applied.
Yes, no, he did not.
Why should we extend this to collection matters?
Well, it would bring the first district into alignment with the only other districts in the state of Ohio that have addressed this very issue in extending it to collections matters. It also makes a lot of sense because it doesn't necessarily, it doesn't conflict with anything that would happen in a personal injury case. So a lot of my work is dealing with medical bills that are involved in personal injury matters. And sometimes we do have these separate actions. We have a collections action with the patient where the patient is also filing a personal injury claim against a tortfeasor. And the court, I believe it was in Seder, addressed this issue where, I'm sorry, it was in Middleton, addressed this issue where there's no danger of conflicting judgments or conflicting rulings in these cases, because in a personal injury case, we're talking about Robinson and Jacques v. Manton and that kind of string of case law where when there's a medical bill submitted, the only evidence that the tortfeasor puts on is any evidence of write-offs. Well, in this case, there wouldn't be any of that evidence because there is no insurance company. There's no health insurance company. There's no workers' comp. There's nothing along those lines. There's no other payer to pay these claims. So by aligning the ruling with the rest of the personal injury case law, there's no conflict.
Would you agree though that the medical bills that are submitted have to be reasonable, that the law requires them to be reasonable, or does that matter?
No, it does. That's well settled in Ohio.
Well, why does it matter?
Well, because a hospital, I mean, in theory there's not really any kind of restriction on that. Hospitals can charge, whatever. I mean, there's market restrictions, but there's no state law that says you can't charge,
like price gouge somebody.
Price gouge, yeah, exactly.
So then, how could we say that the bills are prima facie evidence of reasonableness? Then, what do we have in this case? We have the bills. That's pretty much
correct.
It, right?
Yes, correct. And there's no evidence well, I mean, there was testimony submitted that UC, as pretty much all hospitals do, they conduct studies to see where their charges align with other comparable hospitals in the area, which was the point we were trying to make at the trial court level, that UC is an academic hospital. It's different than going to Ohio Health or going to a non-academic hospital.
But you didn't submit evidence. I think if I recall correctly, the trial judge was having issues with the fact that what you submitted was comparing yourselves nationally to other comparable hospitals nationally, but not locally or regionally.
Right, and again, because it's an academic institution, I believe the closest hospital they could go, there was a hospital in Louisville, a hospital in Lexington, and a hospital in Middleton that were all academic institutions, and found that it was within about the 75th percentile of those charges. But again, our position at the trial court level and our position again here in the Court of Appeals is that evidence is not even necessary. The medical bill, again, with being in line with the Seder and the Middleton decisions, and then going back as far as Wood v. Elzo here, which is Ohio Supreme Court decision, the hospital does not need to present any of that evidence. The hospital's,
They don't have
authenticating
to
medical
present
bill.
evidence of reasonableness.
No, again, because we're relying on the presumption that is kind of the law right now in the state of Ohio, as addressed in a couple of other districts. In relying on that presumption, we've met our burden in establishing the reasonableness of the medical bill.
So if we determine that RC 2317-421 does not apply, then what do you suggest that the evidence that you presented was sufficient?
I do. The issue with, yes, to answer your question, Your Honor. However, the issue with finding it that it does not expand to collections matters or this matter is that there wasn't really any credible evidence that was put forth to rebut the hospital's reasonableness of the charges, or the hospital's contention that the charges were reasonable. The court in this matter took a 2015 case that was unrelated to this case, where that patient was provided an uninsured discount of, I believe, 40%, and then extrapolated that evidence or the facts of that case onto our case to reduce our bill by 40% in the judgment. It strikes me as arbitrary to take facts from another case that wasn't submitted into evidence in any way, shape, or form in this case, and then use that to essentially penalize the plaintiff in this matter.
In follow-up to Judge Bach's question, what if we found that this were just a collection on an account case, similar to other collections on accounts governed by Civil Rule 10? Would your position be that even in that case, the patient could come in and contest the amount as being unreasonable?
Yes. I understand that the way the law is in Ohio is that the patient, regardless of whether they sign, the admission forms and everything, there's either a contract in writing, there's an implied contract for medical services. Either way, the patient is only held to be responsible for the reasonable value of the medical charges. And again, just to be clear with our argument here, the position is only that the hospital is entitled to a rebuttable presumption of the reasonableness by submitting evidence of the medical bill. The patient,
or there's no presumption and it's just an attempt to collect on an account, you still believe that the patient could come in and contest the reasonableness.
correct.
In other words, there's no presumption that it's reasonable. It just is what it is. It's the account. And then the patient can contest the reasonableness.
Right. And I think in that scenario, Your Honor, it would probably play out very similar. The bill is what it is, and the patient can come in and contest it, or we have a rebuttable presumption of reasonableness and the patient can come in and contest it. Either way, in order to grant judgment to my client, the court is going to have to find that the amount of the bill is reasonable. This case is a little bit different insofar as it's a motion for default judgment. So while there was a defendant, the defendant never did appear. There was no evidence submitted to the contrary other than the evidence that the trial court found on its own.
So reasonable would mean basically the hospital's customary charge, right?
In the case of the presumption, yes. It would be the hospital's customary charges.
Okay. And I think the judge asked at the evidentiary hearing, what is the charge or the average amount of money that the hospital typically will settle on? Because everybody knows if there's insurance, there's discounts with the insurance companies. Oftentimes uninsured do get discounts, right? Like they did in the other case that the judge relied on, which you're saying was incorrect. So I think he was trying to figure out what the customary charge is versus what you billed, is what it seemed like he was doing, right?
Right. And so to answer your question, Your Honor, the customary charged amount is the same for everybody. And there's a difference between charges and then accepting as full payment. So the charged amount, whether you have health insurance, whether you have Medicaid or Medicare or workers' comp or a liability claim, or you just don't have any health insurance whatsoever and there's no recourse for your bill and you just owe it, those charged amounts are all the same. If this patient had Anthem health insurance, the charges that would have been submitted to Anthem would be exactly the same as they are on the bill that's in this case. So the charged amount never changes. The amount that's accepted as, payment in full does fluctuate. There's, provider agreements between, the hospital and all these various different private payers. There's a Medicare fee schedule that, that the hospital has to abide by. There's a Medicaid fee schedule that the hospital has to abide by. There's
So
workers.
but then wouldn't that matter then to determine what the reasonable value of the medical services is? Wouldn't
no, Your Honor.
that kind of evidence matter?
Because no, Your Honor, because the amounts that are accepted in those cases, the patient has the benefit of engaging an insurance company in one way, shape, or form. The patient has they pay for that benefit, be it through their employer, be it privately in the marketplace. They are purchasing the ability to access that contract, essentially. Whereas in this case, the patient didn't do that. For whatever reason, there was no health insurance in this case. So the patient doesn't just get the same access as everybody else to these reduced accepted amounts or these contractual negotiated rates, because that's what reasonableness is. The reasonableness amount goes to the charged amount, with the charged amount is the same amount for everybody.
What about situations where the hospital gives an uninsured patient a discount, like they did in the case that the judge relied on? And I think I saw another case out of the first district where there was a 40% discount as well from your hospital.
Yes.
So wouldn't an information like how often these discounts are applied for uninsured patients be relevant in determining the reasonable value of the services?
It absolutely, well, no, because of, again, going back to, it's the reasonableness of the charged amount. The charged amount to those uninsured patients is still the same amount. There is a write-off, essentially. It works similar to an insurance write-off that is provided. Now, that insurance write-off is a little bit different beast. The self-pay write-off is a little bit different.
Mr. Garswood, you are at your time, but I'm going to let you finish that thought, and then if the panel has any follow-up questions.
Sure thing, Your Honor. And Judge Krause, the self-insured discounts are provided pursuant to a federal statute. It's commonly referred to as 501R, which, in order to maintain your charitable tax exemptions, you have to provide a financial assistance policy. It's in writing. Every hospital that has these charitable write-offs, which is most of them, has these policies available on their site. The law that governs these policies basically says that it has to be reasonable. The policy does. So UC's policy is that any patient who is uninsured is entitled to a 40% discount. Now, uninsured includes health insurance, it includes all your government payers, it includes workers' comp, but it also includes any potential liability claim, any potential MedPay claim, any of those things. The patient in this case was involved in a motor vehicle accident claim. Those avenues were available to this patient. We just couldn't get a response. So he was not entitled to that self-pay discount. That evidence is a little bit murky in the record, admittedly so, but Wally Lester, who was the client representative in the record, did indicate that the patient was not entitled to that self-pay discount by way of the hospital's financial assistance policy. So again,
because he didn't engage and try to negotiate this with you all. He just ignored you.
Essentially, he wasn't entitled. Well, one, he didn't apply for it, but two, he also, which is a prerequisite to receiving a charity discount, you have to fill out the application, and that's obviously for tax purposes as well. But also, had he filled out the application, there was an issue with the outstanding motor vehicle accident claim that either was made or could have been made. We don't have any information on it.
Thank you.
Thank you.
All right. You are at your time. Does the panel have any other questions for Mr. Garswood? No. Thank you very much for your argument this morning. We will take the case under submission and give you a timely written opinion. And this will conclude the arguments this morning for the First District Court of Appeals. Thank you very much.
Thank you, Your Honors.